Hi, my name's Louise Merrill. I'm an associate in the employment team at Clarkslegal. This is the 8th podcast in our TUPE in 10 podcast series and will focus on dismissals in a TUPE context. Before we talk through TUPE, it's worth just a quick recap on the standard position with regard to unfair dismissal. The standard position is that employees with 2 years' service qualify from protection against ordinary unfair dismissal. An employer seeking to dismiss an employee will need to show two things. Firstly, that it had a fair reason for the dismissal, and this will be one of the 5 statutory reasons shown on the slide here. And secondly, it needs to show that it acted reasonably in dismissing the employee for that reason. And this involves looking at whether the employer carried out a fair process. And this second point is referred to as the reasonableness test. As well as ordinary unfair dismissal, there are certain reasons for dismissal which will be automatically unfair. These differ to ordinary unfair dismissal cases, as for these, there's no need to look at the reasonableness test. Therefore, if the reason for dismissal is deemed automatically unfair, then the dismissal will be unfair, regardless of the process followed by the employer. Examples of this include dismissals connected to whistleblowing or pregnancy. Now, an important point for us to note is that usually the 2-year length of service requirement for ordinary unfair dismissals won't apply to automatic unfair dismissals. However, there are exceptions to this, and TUPE is one of them that we'll chat through now. Employees dismissed in the TUPE context will of course have the same unfair dismissal rights as others, and so they can bring a claim for ordinary unfair dismissal. However, in addition, if an employee is dismissed and the sole or principal reason for their dismissal is a TUPE transfer, this dismissal will be treated as being automatically unfair. However, even though this is automatically unfair, the employee will still need to have 2 years' service to bring this type of claim. Which employees are protected? The automatic unfair dismissal protection could apply to employees of the transferor who were dismissed before the transfer, whether or not they were employed in the business or services being transferred over. Employees of the transferor who remain behind with the transferor and are dismissed after the transfer. Employees who transfer to the transferee and are dismissed after the transfer by the transferee. And existing employees of the transferee who are dismissed before or after the transfer. Whether the sole or principal reason for the dismissal is the transfer will be a question of fact, taking into account all of the relevant circumstances. Dismissals for reasons totally unconnected with the transfer may be unfair under ordinary principles, but they won't be automatically unfair, for example if the individual is dismissed for misconduct. The TUPE regulations make clear that where the sole or principal reason for the dismissal is an economic, technical or organisational reason entailing changes in the workforce, which is called an ETO reason, the dismissal will not be automatically unfair under TUPE, but the ordinary unfair dismissal rules will apply. And the onus on establishing an ETO reason will fall on the employer. So what's an economic, technical or organisational reason? Now this could include a reason relating to the profitability or market performance of the company, a reason relating to the nature of equipment or production processes, a reason relating to management or organisational structure. And then you need to look at this entailing changes in the workforce part of the test, and what does that mean? So changes in the workforce typically mean a change in the number of employees, a change in the workplace, or a change in the functions of employees. And it's not necessary for the change in function to affect the whole workforce. However, a minor change in the function of a small number of employees may not be sufficient. It can be difficult to know if a reason will amount to an ETO reason. Obviously, a genuine redundancy situation will usually be for an economic or organisational reason, and it will usually result in the reduction in the number of employees, and so it usually satisfies the ETO reason test. There have been other less obvious examples in the tribunals, including that in the case of Nationwide Building Society and Ben and others. In this case, employees transferred to Nationwide, which had a much narrower product range than their previous employer. A job mapping process was carried out pre-transfer without the employees' involvement, and their roles were changed to align to roles within Nationwide. As a result of the narrower product range, some managers felt that key aspects of their roles had diminished, and they resigned, claiming constructive dismissal. It was held that on the facts, Nationwide's limited product range did amount to an organisational reason, and as it entailed changes to job functions, there was an ETO reason. It should be noted, however, that this case was remitted back to the original tribunal to determine whether the dismissals were unfair under ordinary principles, given the lack of process followed with individuals. This decision does need to be treated with caution, and it should be remembered that changes to simply harmonised terms will not be permitted under TUPE. Unsuccessful ETO arguments have also been advanced in the tribunals and include, for example, a situation where the transferee requests the dismissal of employees pre-transfer as a condition of sale, where that's got nothing to do with the running of the business. And there was also a case where an administrator effected dismissals to make the business more attractive to potential buyers, and that was not a valid ETO either. This is a notoriously tricky area of law, and case law is extremely fact-sensitive. It's obviously outside the scope of this short podcast to explore this further. However, you can contact our employment team for more information, and you should obviously seek appropriate advice if you're intending to rely on an ETO reason in a TUPE context. So who's liable in a TUPE situation for dismissals? Let's start with the transferor. The transferor will be liable for the unfair dismissal of any of its employees who are not in scope to transfer, whether they're dismissed before or after the transfer. It will also be liable for any of its employees that are in scope who are dismissed pre-transfer for an unconnected reason such as misconduct. The transferee will be liable for the unfair dismissal of any of the transferor's employees who are in scope to transfer and are dismissed by the transferor before the transfer, where the sole or principal reason for the dismissal is the transfer. And the transferee will also be liable for the unfair dismissal of any of its employees, and this will include dismissals relating to its existing workforce before and after the transfer. And of course, the transferee inherits employees under TUPE, and so it will also be liable for any dismissals of these transferring employees after the transfer. If an employer commits a repudiatory breach of contract, which is a serious breach allowing the employee to treat the contract as having come to an end, and the employee resigns as a result, the law converts the resignation into a dismissal, and this is called a constructive dismissal. In a TUPE situation, an employee who would otherwise be in scope to transfer to the transferee could resign, claiming constructive dismissal, relying on a repudiatory breach of contract committed by the transferor pre-transfer. It's also possible for the employee to resign in response to an anticipated future breach by the transferee. The resignation may or may not be accompanied by an objection to the transfer, and this is important as it determines who will be liable, the transferor or the transferee. If the employee objects to the transfer as well as resigning, then the transferor retains all liability as the employee's contract will not transfer. If, however, the employee resigns without objecting to the transfer, then the usual position under TUPE applies, and the transferee will be liable if the sole or principal reason for the constructive dismissal is the transfer. And the normal unfair dismissal remedies are available to employees who are automatically unfairly dismissed under TUPE. And so we've not gone through these here, but details on the type of compensation available in unfair dismissal claims can be sought from our employment team if you need this. And that brings us to the end of this podcast. I hope you found it useful. The next podcast in our TUPE in 10 series will focus on information and consultation obligations under TUPE.